Hello and welcome to Unacademy. Welcome to the Polity Project. The topic for today, removal of judges. Justice Yashwant Varma may become the first judge ever to be removed by the president based on the recommendations of the parliament, unless Justice Yashwant Varma decides to resign from the office. Dr. Ambedkar, he was asked, which constitutional office do you think is the most important? He replied, Office of the Comptroller and the Auditor General of India, CAG. Next, the judges of the Supreme Court and High Courts. That is why independence of judiciary should be ensured and strengthened and encouraged. Because judges, while deciding the cases, should not come under the influence of the political class. Because imagine if the judge is hearing a case against the union government and the judge is under the influence of the union government, how will this judge be able to give justice in this case? That is why Constituent Assembly took a lot of effort to ensure independence of judiciary, and that is how various provisions were incorporated into the constitution to ensure independence of judiciary, such as although the judges are appointed by the president, but they don't hold office during the pleasure of the president. At any point in time, the president cannot remove these judges from the office. The judges hold office till they attain a retirement age, which is 65 for a Supreme Court judge, 62 for a High Court judge. This is to ensure independence of judiciary. Second, the salaries of the judges are charged on the consolidated fund. Salary of a Supreme Court judge is charged on the Consolidated Fund of India. The salaries of the High Court judges charged on the Consolidated Fund of the state, which means once the salary is decided, then the salary need not wait for parliamentary approval to get credited into the account of the judge. This is to ensure independence of judiciary. And judges have the power to punish people for contempt. For example, if there is an individual who is scandalizing the institution of judiciary or interfering with regards to the giving of judgments, then that individual can be charged with contempt by the courts. This is to ensure independence of judiciary. Also, the conduct of judges cannot be discussed in the parliament, in the state legislatures. Again, this is to ensure independence of judiciary. And these judges are removed by the president based on the resolution passed by both houses of the Indian Parliament. A very complicated process. And such a complicated process that till date no judge of the Supreme Court or High Courts has ever been removed. This was to ensure independence of judiciary. But the Constituent Assembly thought, although independence of judiciary should be ensured, but we still have to keep a check on the judiciary. So there has to be checks and balances on the judiciary. Checks and balances how? Through appointment and removal. Judges will be appointed by the president. Judges will be removed by the president, but only on the basis of the resolution passed by both houses of the Indian Parliament. The Constituent Assembly thought that through appointment and removal, we can keep a check on the judiciary. Otherwise, there is no check. But we still need to ensure independence of judiciary, and that we can ensure through these constitutional provisions. But we may say that today there are no checks on the judiciary, or at least this is the allegation. Because through appointment, the Constituent Assembly thought that we can keep a check on judiciary. But now this appointment process has been arrogated by the courts to itself. India is perhaps the only country where judges are appointed by themselves through a very opaque process known as the collegium system of judicial appointments. And as I told you, such is the complicated process of removal of a judge that till date no judge has ever been removed through this process. But if at all we need to remove a judge, let's say the judge of a Supreme Court or the judge of a High Court, for that Constitution prescribes some grounds. Constitution says the judge is appointed by the president and the judge can be removed by the president. But how? On the basis of the resolution passed by parliament by a tougher majority known as special majority, which is majority of the two-third members present and voting plus majority of the total membership of the house. But on what grounds? On the grounds of misbehavior or incapacity. What is incapacity? For example, I am appointed as a judge and I am in sound mind. But once I was appointed, after a few years or after some time, I became mentally unstable. You may have sympathy with me, but you can't entrust me with the responsibility of ensuring justice, delivering verdicts, delivering judgments, which means on this ground, incapacity. Now, I don't have the capacity to act as a judge because of my unsound mind. I can be removed by the president based on the resolution passed by the parliament. Or misbehavior. For example, Justice Yashwant Varma, who was the then judge of a Delhi High Court. From his premise, official residence, half burnt cash was recovered. Amounts to misbehavior. And on this ground, this judge can be removed from his office. But Constitution does not elaborate how. Constitution does not define what is this misbehavior, what is this incapacity. The entire process is mentioned in a law passed by the parliament known as the Judges Inquiry Act of 1968. Which means if the judge is to be removed by the president based on the resolution passed by both houses of the Indian Parliament by special majority, what is the process? The process is if 100 MPs of Lok Sabha write to the speaker, or if 50 MPs of Rajya Sabha write to the chairman that, sir, we want to remove the judge of a high court or Supreme Court on the grounds of misbehavior or incapacity. Once this motion is sent to the chairman of the Rajya Sabha or the speaker of the Lok Sabha, then becomes the discretion of the speaker or the chairman. They may accept or reject this motion. For example, in 2017, when the opposition in the Rajya Sabha tried to introduce a motion to remove the then Chief Justice of India, Justice Deepak Mishra, the then chairman of the Rajya Sabha, the Vice President of India, Mr. M. Venkaiah Naidu, he rejected this motion. Which means important thing that you have to keep in mind is that this motion, there is a discretion on part of the speaker or the chairman. They can accept or reject this motion. But if they accept, then this speaker or the chairman will have to set up a 3-member committee. This 3-member committee will investigate into these allegations of misbehavior or incapacity. What is going to be the composition of this 3-member committee? One, we may have a Chief Justice of India or somebody nominated by the Chief Justice of India, which means the judge of a Supreme Court. Second, we will have a Chief Justice of a High Court. Third, we will have a distinguished jurist. This 3-member committee will have to be set up by the chairman or the speaker. They will investigate, inquire into the allegations of misbehavior and incapacity. For example, in case of Justice Yashwant Varma, listen to me carefully. Motion was introduced by Rajya Sabha MPs as well to the then Vice President, to the then Chairperson of the Rajya Sabha, Mr. Dhankar. And motion was introduced by Lok Sabha MPs as well, 146 MPs of the Lok Sabha to the Speaker of the Lok Sabha at the same time. The law says if the motion is admitted at the same time in both the houses, then this 3-member committee will have to be set up jointly by the Vice President as well as the Speaker, by the Chairman of the Rajya Sabha as well as the Speaker, because Chairman of Rajya Sabha is the Vice President of India. This is considered to be one trigger which led to the resignation of the Vice President of India. But be that as it may, then we were told that this motion was not accepted by the chairman of the Rajya Sabha, which means this motion was admitted in Lok Sabha only. And now the Lok Sabha speaker has set up a 3-member committee. One, Justice Arvind Kumar, who is the judge of the Supreme Court. Second, a Chief Justice of Madras High Court. And third, a distinguished jurist, B.V. Acharya, who is the senior advocate of the Karnataka High Court. They will have to inquire into the allegations of misbehavior against Justice Yashwant Varma. But what if this report says, and this report conclusively proves the allegations of misbehavior against Justice Yashwant Varma? Does that mean automatically the judge will be removed? No, because after all, it depends upon the parliament. Because even if the committee finds that this judge is guilty, after all, it boils down to numbers. Whether in both houses of the Indian Parliament, we have the special majority to recommend to the president removal of Justice Yashwant Varma as the judge of a high court. But now listen to me carefully. Shouldn't judges be accountable? And who are they accountable to? For example, when Justice Yashwant Varma, who was then the judge of a Delhi High Court, when from his premise half-burnt cash was recovered, matter went to the Chief Justice of the Delhi High Court. He reported this matter to the Chief Justice of India, Justice Sanjeev Khanna. And Justice Sanjeev Khanna set up a 3-member in-house committee. It's not that judges are not accountable. Judges are accountable. And there is a well-defined, beautiful process, in-house process in the court itself. The Chief Justice of India set up a 3-member committee. And before that, the Chief Justice of India transferred this judge to Allahabad High Court. Now, you may ask why. Because Justice Yashwant Varma's parent High Court was Allahabad High Court. This is where he started his judicial journey. And he was sent back, transferred to Allahabad High Court, but without assigned any cases. He will not take up any judicial work. He will be transferred to Allahabad High Court because that's your parent High Court, but you will not take up any judicial work pending the inquiry conducted by this in-house committee. And this 3-member in-house committee was set up by the then Chief Justice of India. And 3 members were Chief Justice of Himachal High Court, Chief Justice of Punjab and Haryana High Court, and a judge of Karnataka High Court. They conducted this inquiry, and we thought, or we were told, that this inquiry has conclusively proven that yes, Justice Yashwant Varma is corrupt. The allegations have been proven. Then Justice Yashwant Varma was asked by the Chief Justice of India to resign. He refused. When he refused, then now the ball is in the court of the parliament. 146 MPs of Lok Sabha have written to the Speaker that please initiate the process so that we can remove this judge. Now a 3-member committee has been set up. We are awaiting the report of this 3-member committee. And then the ball is in the court of the parliament. Both houses of the Indian Parliament will have to pass a resolution by special majority. Then the matter will be sent to the president. And it becomes binding on the president to remove this judge. Because this resolution, which will be passed by both houses of the Indian Parliament, this resolution is what we call a statutory resolution. And a statutory resolution is binding on the president, binding on the government. But now you tell me something else. This judge, who, if proven that yes, he was guilty of corruption, misbehavior, should the matter end with removal of the judge? That's it. Shouldn't an FIR be filed? Case be investigated by the police? And finally, if the investigation takes place, the matter should go to a trial. And then the court should punish this individual and send him to jail. Because that's what happens to an ordinary individual, to a public servant who has committed an act of corruption. This matter should not end with Justice Yashwant Varma's removal. Although newspapers incorrectly use the term impeachment, the judges are not impeached. Only the president is impeached. All other constitutional functionaries are removed. Vice president is removed. Judges are removed. CEC is removed. But only the president is impeached. But shouldn't this matter reach the court and then this judge should be punished if at all you are guilty of corruption? That's point number 1. Point number 2. There is a demand that we need a judicial complaints commission. For example, Prashant Bhushan, a noted Supreme Court lawyer, his father as well, the late Shanti Bhushan, they say that 8 of the last 16 Chief Justices of India were corrupt. They even gave the proof on affidavit that 8 of the last 16 Chief Justices have been corrupt. But only we have this in-house committee, or we have the option of removing that judge from his house, from his post, based on this complicated process of removal, which till date no judge has ever been removed. For example, even when this committee, which was set up in 1990s against Justice V. Ramaswamy, he was also accused of corruption. The three-member committee set up by the Speaker of the Lok Sabha proved that yes, Justice Ramaswamy is corrupt. But Congress party abstained from voting, and ultimately the judge could not be removed from his office. So either for accountability, we have this in-house committee, or we have the complicated process of removal, which is ineffective. Then what do we need? We need a judicial complaints commission so that you, me, common individuals, Aam Aadmi, can approach this commission if we have proof or if we allege corruption in the judiciary. Who will be part of this, or who should be part of this judicial complaints commission? Maybe retired judges. Let's have 5 retired judges of the Supreme Court and High Court. They will form this judicial complaints commission. You and me, we have a proof against a particular judge. Submit this proof to this judicial complaints commission. And if they see that prima facie, on the face of it, there is some merit in your allegations, let's do a trial. Let's do an investigation. And then this judicial complaints commission should order the removal of a judge. This matter should not go to the parliament because that route has been proven to be ineffective. This matter should not go to the parliament. This matter should go from this judicial complaints commission to the President of India, and it should be binding on the President to remove that judge. Because we need this judicial complaints commission, because existing in-house committee or the removal process are ineffective. If there is corruption in the society, there may well be corruption in the judiciary as well, because after all, these judges are derived from our society. They are also part of the society. If the society has elements of corruption, judiciary also will have elements of corruption. But our existing mechanism is ineffective to deal with the allegations of corruption. We need something else. And that something else is Judicial Complaints Commission. But this commission should be independent of both judiciary as well as legislature, judiciary as well as executive. Let's have retired judges, or let's have members from the civil society who will be part of this Judicial Complaints Commission. They will accept complaints from the citizens. They will inquire into these allegations. They will put this judge on a trial and then recommend to the president, remove this individual. But there should be no interference by the judiciary, no interference by the executive or the parliament. Maybe the idea of a judicial complaints commission should fructify, because no one can stop an idea whose time has come, and the time has come for judicial complaints commission. This question on your screen from the Prelims examination 2019 was asked. And based on whatever you have listened to in this lecture, let me see if you can answer this question, and type in your answer in the comment section. Consider the following statements. The motion to impeach a judge, but sir, you said judges are not impeached, the judges are removed. UPSC can also make a mistake in asking a question. So this is UPSC's mistake. The motion to impeach a judge of the Supreme Court cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act. Can be. That's what I've told you. It is the discretion of the Speaker and the Chairman. The Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. It doesn't define. It just says the judge can be removed by the President based on the resolution passed by Parliament. On what grounds? Proved misbehavior and incapacity. But this phrase is not defined and elaborated. The details of the process of impeachment of the judges of the Supreme Court of India are given in the Judges Inquiry Act of 1968. Correct. It's a statutory law. If the motion for impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by majority of total membership of that house and by not less than 2/3 of the members present and voting. Correct? So 3 and 4, C is the right answer. So this was a crisp explanation of how the judges are removed, what is the concept of independence of judiciary, what is this in-house committee, should there be a need, is there is a need, but should there be the establishment of a judicial complaints commission? What is your take on this matter? Do let me know in the comment section, and don't forget to like this video and subscribe to our channel if you haven't yet. I'll see you again tomorrow, same time, same channel. Till then, have a great time. All the best.